Session number 2 on judiciary. Panelists are already here. And this session is going to be most interesting and informative, I am sure. We have a great panel. We are lucky to have those people, those who decide the matter and solve the issues and resolve the complex legal issues are here on this panel, along with the people who plead the matter and who teach the matter. It's a very rare combination. So those who decide, those who plead, and those who teach are amongst us today. Judiciary and the entire judicial system is in the news every day. And I'm sure the session chair will take and touch upon all the relevant aspects. Over to our learned friend, Gaurav Kejriwal. Thank you.
Ladies and gentlemen and fellow Sindhis, welcome to the second session of the Delhi NCR Soba's Networking and Leadership Conclave, Transforming the Future by Enabling the Leaders of Tomorrow. The leaders of future have to be aware and alive to the importance or the supremacy of the Constitution of India and the constitutional framework which has allowed the country to grow as a nation in the past 75 years. The need for a written constitution was a product of our freedom struggle. After having been dominated and ruled by the British for more than 200 years, the people of India realized that the freedom of a nation had come at a huge cost and after a prolonged struggle. As such, we the people of India should have the right to self-governance with the democratic right to choose and elect a government of our choice, a government that would uphold the freedom and liberty of its citizen and ensure that the fundamental rights of every individual citizen is respected. Recent media reports, as my learned friend just mentioned, which have engaged our attention over the past few months, relate to constitutional principles of basic structure theory of the Constitution, interference with the functioning of an elected government, appointment of judges by the judiciary, and rights of citizens, not only to lead a life of dignity and the right to carry on trade and commerce, but also the right to privacy. The origin of the idea or the concept of supremacy of the Constitution dates back to the 1700 AD. The American Constitution was the first to designate its Constitution as the supreme law of the land. No authority created under the Constitution is supreme. The Constitution is supreme and all the authorities function under the supreme law of the land. So what exactly is a Constitution? Simply put, a Constitution is a fountainhead from which other laws must flow, and it must grow with the growth of the nation, with the philosophical and cultural advancement of the people who gave birth to it. A Constitution is a set of laws and rules setting up machinery of the government of a state which defines and determines the relationship between the different institutions and area of governance, the executive, the legislature, and the judiciary, the central and the state and the local governments. The Constitution can be amended. In our parliamentary democracy, the Constitution has been given the high place, and all public authorities holding public office swear their allegiance to serve and in aid of the Constitution. To throw more light on some of these issues, because each of these issues are very big topics and worthy of sessions alone, but here we have an elite panelist who will try to educate us on some of these issues. And first and foremost, we have Justice Navneeti Prasad Singh, a former Chief Justice of the Kerala High Court, who joined Scindia School in 1963 in the junior section and passed out from school in 1973. While at school, Justice Singh was the House Prefect and Athletics Captain. Justice Singh was elevated to the bench in 2006 and thereafter appointed the Chief Justice of the Kerala High Court, from where he superannuated in 2017. And since then, he has been practicing as a senior advocate in the Supreme Court and is also part of several arbitrations which are being carried on. Among the many judgments that Justice Singh has authored, one that stands out is the judgment striking down the Bihar government's liquor prohibition law. And I must say that incidentally, I challenged the same in Supreme Court. Justice Singh would be addressing us on the evolution of the Constitution and the development and why is it supreme. Justice Pankaj Bhatia, he is a sitting judge of the Allahabad High Court and is presently presiding at the Lucknow bench of the Allahabad High Court. Justice Bhatia passed out from the Scindia School in 1984 and was elevated to the bench in 2018 as an additional judge and was confirmed as a permanent judge in 2020. Justice Bhatia is also the president of the Allahabad chapter of the SOBA. Justice Bhatia would be addressing us on the basic structure theory, the power to amend the constitution and the need for recognizing the basic structure theory and the relevance in modern day. Then we have a very distinguished educationist, Professor Dr. C. Rajkumar, who is the founding Vice Chancellor of the O.P. Jindal Global University, a leading light in the field of legal education. A Rhodes Scholar, Professor Rajkumar academic qualifications both from University of Oxford and the Harvard University. He was appointed as the Vice Chancellor of the Jindal Global University at the age of 34 in 2009. He has 7 books and over 150 publications to his credit and has been published widely in peer-reviewed journals, law reviews in Australia, Hong Kong, India, Japan, Singapore, UK and the USA. Professor Dr. Rajkumar will be speaking on the legal education in the context of transforming the future by enabling the leaders of tomorrow. Then we have Mr. Devashish Bharuka, a die-hard Scindian, did his master's in law from the Harvard Law School after passing out from Scindia School in 1995. He has been practicing law in Delhi for more than 2 decades. He is presently the additional standing counsel for the state of Bihar in the Supreme Court. He has been the joint treasurer of the Supreme Court Bar Association and the former president of the Harvard Club in India. Mr. Bharuka would be taking us through the evolving rights in view of changes in societal norms and the digital world and how the courts have been recognizing and expanding the scope of right to life. With this, I would first like to invite Justice Navneeti Prasad Singh to give us a little bit of outline of the evolution of the Constitution of India.
Thank you, Gaurav, and respected audience. Most of you are Scindians, and therefore, cutting all pleasantries amongst friends, I'll, to save time, get into the topic straight away. Evolution of Indian Constitution and development, why it is supreme. Now, instead of being very academic, I will try to be down to earth, something which everyone would understand and appreciate. To understand what a constitution is, what our constitution is, it's better to first see how it came about and what was its necessity. Now, you don't have to be a student of history to know as to how India, as we know today, which it was not 300 years back, was governed. It was a whole lot of sovereign states spread all over, ruled by individual rulers. They had their own system of administration. Forgetting the Mughal invasion, the British, the Portuguese, the French, then they came. That is the East India Company, the Portuguese East India Company. Now they started exploiting the richness that was available here. You must have heard some lectures which brought about that 25% of the world GDP was India in the 16th and 17th century. Now that is what they came down for. The East India Company started merely as a trading company which stepped forward. The more influence they had, then they became rent collectors. Now that is how the zamindari system came about, that they would collect the rent for whoever the sovereign or the authority was and share it with them. So it was, they would say that in this area, we will get 1,000 rupees, we will pay the Nawab or whoever 900 rupees, 100 we would keep. That went on, and with that they started exercising certain other rights. The exploitation went to such an extent that in 1857, what we were earlier taught was the mutiny, which we rightly now say the first war of independence, that was there, and the British realized that it is difficult to control India even for their interest. So what they did was they nationalized the East India Company. The British Parliament nationalized the East India Company and the Crown steps in. Now it is 1857 that the Crown came in. Now keep in mind, what was the interest of East India Company? It was trading and exploitation of the resources available in India. When the Crown came in, it gave a legal sanction through the Crown to exploit India, what we know as a colonial economy. Now a GDP of 25%, world GDP of India, started coming down. The reason was cotton picked in Gujarat, not to be processed in India, but taken out, processed in England. So the secondary commerce generated in England. Along with that responsibility, when the Crown stepped in, was to administer India. Therefore, the laws that were being formulated by the Crown for implementation in India was basically for the benefit of Crown, which is outside India. So all the laws were designed for the benefit of the Crown at the expense of India and Indians. It's unfortunate that today we still have some of those laws continuing. One of them is the Telegraph Act, which says that it is the sovereign privilege of the government to control and have the right of telecommunication. Now, I find it totally incompatible with the Constitution. But then, well, for various economic reasons, they kept it there. Now, therefore, all the laws that were being made were with the object of governing India for the good of the British. That is when the Second World War came, and then an obligation to transfer power and declare India as an independent country. The India Independence Act 1947 was passed by the British Parliament. The question immediately came that till now we have had laws for governing Indians for the benefit of the Crown. Now the Crown is vanishing, what to do? In the Indian Independence Act itself, a provision the British had made that now there would be a constituent assembly for framing the constitution. So far as India is concerned, it went very well. Pakistan was not there at that time. But it was evolved that Pakistan will come, and when it comes, it will have a constituent assembly. That is how our Constituent Assembly came. Now the job before our Constituent Assembly was now to draw up a document which was to replace the Crown and shift the allegiance from the Crown to the Constitution. What people forget is that the greater and the major role was a shift from to be governed to govern ourselves. And unfortunately, even today we have a lot of people who don't understand this concept and who still are feudalistic in their approach. Now what I am trying to say is, just think. Previously, the Crown was governing us for its good. Now we have a constitution, and what it starts with, the first few words in the preamble, we the people of India give to ourselves this constitution on so and so date. So it's not Crown who is granting us any privilege. It is not any individual who is granting us privilege. It is we who is bestowing us our own privilege. And we are providing for our governance, not for governance for the purposes of Crown. Now there is a total shift of vision. For whom you work here. Earlier, 47, pre-47, you were working for the Crown. Everything you did was for the Crown. Post-47, you were doing it for yourself. Now, people don't realize when Sardar Patel said, do away with permit quota system, what it actually meant. These permit quota system were licenses to control. But who do you control today? Everything is yours. Now you have to regulate and not control. Now that was the significance which people didn't understand. People don't understand even today that when Article 19 says these are the fundamental rights of a citizen, it is not conferring any right. It is recognizing a right of an independent country, the citizenry of the independent country. Even today, unfortunately, in courts, we have judges still saying, where do you have the permission? From whom do you have the permission? Instead of saying, where is the restriction? Now the whole concept had to change. That is how this constitutional document was made for self-governance. Now each time we talk of public servant, we always say in the lighter sense that for them public is the servant, whereas it's just the other way around. They are to serve the public. But the British colonial thought that the IAS, the executive, is there to govern, has not got over them. Now when we had the Parliament, what is Parliament repository of? It is virtually of the people, by the people, for the people. It is no more a crown or for the crown, by the crown, of the people to the crown. So everyone has to change his mindset. And in this country, the constitution having been so made for achieving that transition, we have to start thinking in those lines. Only then can we call ourselves truly republic. Now that is another issue which most of you would wonder, what was the great charm in calling India a republic in the constitution? Just think, what is the Australian flag? What is the New Zealand flag? They still have a Governor General sitting there from England, the Crown representative. All acts of the Australian Parliament has to have the seal of the Crown. We decided to break that by our constitution. We declared ourselves republic from every country. Australia is still bound. New Zealand is still bound. Now after the Queen's death, there is talk to get rid of that. We did it way back in 1950. Now this is what the whole concept of the constitution is. Now while making the constitution, it thought of three limbs: the legislature, the executive, and the judiciary, as the three pillars of any democratic constitution, and has tried to keep each in its own ambit so that there is least clash and there is checks and balance. Now, there is always a debate as to who is supreme. We recently had a controversy start where an eminent personality said that it is the will of the people that should prevail and not the will of two judges. Unfortunately, that is not constitution. The judges who are unelected, uncommitted to any particular ideology have been given the task by the constitution to decide what is constitutional, and not a political body committed to a philosophy to lay down what the country will be. And that is why the role of judiciary to check on the other forums. Otherwise, we would be heading to what has just happened, is happening in Israel today. The Prime Minister Netanyahu there is passing a legislation whereby the executive is given power to overrule the judgments of the Supreme Court and declare it null and void, saying that the parliament represents the will of the people and not the court, forgetting a very small distinction that if that were so, and with Justice Bhatia will deal, is that tomorrow, let us say for some vague reason, we were to elect the government which was totally a communist government. They would not only wipe out right to property, right to business, right to free speech, everything, so Article 19 goes. What remains of your constitution? Now, something had to be preserved. Justice Bhatia will speak how we evolved this basic structure. Now, in Israel, there is a big protest. But being there a clash between the judiciary and the legislature, they are formulating a law overriding the judicial autonomy. Lot of multinational companies and big companies, they are going out. Because they say then we will be just slaves of the parliament. Now that cannot be in India. Our constitution does not permit it. The debate as to who is supreme of the three, unfortunately neither of them. Each plays a dominant role in its own sphere, and what is ultimately supreme is the constitution. And constitution says how things will operate. For example, so far as judiciary is concerned, there is one article 141 which says the law laid down by the Supreme Court shall be the law of the nation. Now you may just question that law made by the parliament is the law. Now law made by the parliament is a legislation, the interpretation whereof is in the hands of the judiciary. And the interpretation given by the judiciary is the law. Because otherwise, the parliament would interpret its own law in its own way. So there when it comes, the role of judiciary is dominant. But then what the law should be is left to the legislature. Now the judiciary can't start enacting laws. You must have read just yesterday where the Supreme Court refused to interfere in a leave matter, saying that it's a policy matter left to the government. There are many matters where the Supreme Court says it's a matter of legislation left to the parliament. Adjudicatory, yes, we will do it. So ultimately, neither the legislature nor the judiciary nor the executive is supreme, it is the constitution which is supreme. Now, my effort was to just thought provoke you into something which is not generally talked and which is not purely legal. Thank you.
Thank you, Justice Navneeti Singh. May I now invite Justice Pankaj Bhatia, who will be speaking on the basic structure theory.
Good afternoon, fellow Indians, ladies and gentlemen. I am very thankful to Brother Navneeti, who has given a broad outline of what a constitution is. And the manner in which he has explained was helpful to me also. Now we have to deal with two aspects. I have been told to speak on the basic feature of the constitution and the power to amend, which lies with the parliament. The genesis of this whole thing flows from two articles. One is Article 13, which says that any law made which is in derogation of the constitutional and fundamental rights would be a void law. It will be a bad law. However, there is a power conferred upon the parliament to amend the constitution, and that flows from Article 368. 368 says that you can amend the constitution by a two-third majority present and voting, not the total two-third majority of the Lok Sabha and the Rajya Sabha. It has to be present and voting. Now this power of amendment, although a very, very necessary power, created a lot of problems after independence and after the constitution came into being. The first started incidentally with Bihar. There were some agrarian reforms, and the constitution was also amended to say that these cannot be touched by anything. Then came the judgment of one Shankari Prasad, which agreed with the government and said that yes, Article 13 applies only to laws. The amendment of constitution has nothing to do with Article 13. We continued with this for good 14-15 years. Then another amendment came which was again challenged in the case of Sajjan Kumar. Once again, the Supreme Court says yes, article by a majority of 3:2, yes, Article 13 pertains only to laws and not to the constitutional amendments. Although some discontent theory was shown by the two dissenting judges who said that no, this is going too far. Later on, ultimately, came the judgment of Keswanand Bharti. Keswanand Bharti for the first time evolved a theory which is known as the basic feature of constitution. Various arguments were read by so many people, including the great Mr. Nani Palkhiwala. The debate was whether the basic feature should be found within the constitution, or is it some kind of an abstract principle that has to govern and to come to this. Incidentally, Mr. Nani Palkhiwala gave certain examples which are relevant even today. He said that the constitution was framed by the Constituent Assembly as told by Brother Navneeti. At the end of the framing, a preamble was written. It was done at the end. And therefore, one of the theories was that the preamble gives you a guideline for what the basic feature is. It says we the people will be sovereign. Later on, socialist was added, a republic, democratic. He gave an example. Suppose today the government by a two-third majority, which is very easy to garner today, says that all right, we will be subservient to the crown. We don't like the manner in which we are working, and therefore that crown system was better. We will always be subservient to crown, like in the case of Australian constitution. Suppose the government says all the news channels which are projecting the news are giving fake news. Why don't we nationalize the press? And we'll give our own channel, will give the news, which will be considered to be a good news, and everyone has to read that. Then he said, suppose they say universal adult franchise, everybody can vote. He says, no, this will go away. The voters can be only persons who are graduate or postgraduates, or who people pay income tax, and therefore only they can vote. Now these are the howlers that were thrown at the bench to suggest what happens then. The power is there, they can amend, no problem with that. That is where for the first time the Supreme Court coined the phrase known as basic feature of a constitution. He says there is something which is the nucleus, you can add something to it, you can subtract something to it from it, but you can't disturb that nucleus. That is where it started. Thereafter various judgments came. One of them was Raj Narayan versus Indira Gandhi. Indira Gandhi, as we all know, lost the election. Allahabad High Court said that the election was bad. That was challenged in the Supreme Court. During that challenge, an amendment came. It says that election to 4 offices cannot be touched by the judiciary, and they will be decided by the law yet to be framed. And therefore, the appeal that was pending in the Supreme Court could not be decided because the law was yet to be framed. Now that again came up for challenge, and all the 5 judges then unanimously said, no, this is going too far. The reasoning given by all 5 of them were different. But that is how the principles, which are although not stricto sensu mentioned in the Constitution, evolved like rule of law. Now rule of law will prevail over everything. This became a basic part of the basic feature. Violation, there has to be equality. If the election can be challenged, it can be challenged to any office. If there is something wrong, the election will go. Now these were the principles which developed over a period of time through various constitutional pronouncements. Now the question comes whether they are needed or not. Where did the Supreme Court come with these principles? Last was the NGAC judgment, where the right of the government to appoint judges was struck down by the Supreme Court, saying, you can't do it in this manner because it will affect the independence of judiciary. So one of the principles that came was that independence of judiciary is absolute. You cannot touch it. Now these are the principles which were evolved over a passage of time. Now whether they are needed or not. The second part of my topic is what is the relevance in the modern day. The examples given by Mr. Nani Palkiwala, I have mentioned some of them, are relevant even today. We are a nation which decides basically on emotions at that point of time. Today, the government may feel why a particular religion should be allowed to vote, why a particular religious dominations should not be curtailed, and why the majoritarian religious denominations should be allowed to do whatever they want to do, and blah, blah, blah. There can be 100,000 examples. The Constitution in Keswa Anand Bharti stares on the face of it, you can't do it. We are a diverse country, all have to go. Every 200 kilometers, the language changes, the religion changes, the practices change, everything changes in every 200 kilometers, we are such a vast country. And therefore, any one view, that my view is a correct view, cannot find any place in the constitutional scheme of things that we have. And therefore, the doctrine that was developed will always remain. It has evolved and it will keep on evolving depending on the challenges that are thrown. And that is where the role of the judiciary is one of the most important roles. Although at times the judiciary also steps that line which should not. But you can't see that without these 3 limbs working in tandem and in their fields, the Constitution as a document is likely to fail, and that is what India cannot want. And the beauty of India is that the Constitution is a living document. It keeps on changing depending on the need of the hour. So that is how I think we should preserve the Constitution. We should all deeply go into the constitutional things. It cannot be said that it is just a document which is lying somewhere in the drawer for the lawyers and the judges to read. it should be read by all, it should be inculcated in the school, and then and then alone we will be able to achieve the objective which was thought at the time of framing of the Constitution. I hope I have not bored you people. Thank you.
May I now invite Professor Dr. Rajkumar.
Okay. Very good afternoon. Can you hear me? All right. Very good afternoon to all of you. First of all, I'm a bit of a trespasser here. I'm not a Sindhian in that sense, but it's a pleasure to be in the company of these outstanding alumni of Scindia. The only thing I did was in 2015, I gave a talk at Scindia School, and apparently a few students heard that, and then they joined us in our university, and since then, every year we have a significant number of Scindia graduates joining several of our schools, and so I want to pay tribute to the outstanding generations of alumni of Scindia School. All right, I'll also quickly, the two judges in the panel have been very erudite about the history and evolution of constitutional law and constitutionalism and rule of law. I want to start that debate or rather discussion by moving into the core of my own reflections on legal education. Quite remarkably, I think some people here in this room obviously know that the true leaders of the Indian freedom movement happen to be lawyers, which makes it very special because clearly Mahatma Gandhi was a lawyer, Sardar Patel was a lawyer, Nehru was a lawyer, Ambedkar was a lawyer, Rajendra Prasad was a lawyer. In fact, the entire framework of the Indian freedom movement struggle happened to be led by lawyers. And one would think that in 1947, when lawyers led the freedom movement and occupied the cabinet as ministers, one of the most important aspects of the higher education which ought to receive greater degree of focus and attention should have been or could have been legal education, but unfortunately that was not the case. In fact, the early evolution of great institutions in India happened to be not in the field of law. It clearly was in the field of STEM. We all know the evolution of IIT Kharagpur and of course a series of other IITs and then IIMs, and also in medical education, some other institutions. So there was clearly not an attempt, at least at that stage, to recognize the role of legal education and its potential relevance to the development of a nascent democracy that India was in 1947. In fact, it took several decades. There were pockets of excellence in legal education in certain parts of India, but by and large, it is only fair to say that the professional and academic and intellectual engagement in the field of law through the role of universities was not something that we saw till very late. In fact, this aspect of the evolution of Indian legal education all the way from 1947 till I would say 1987, when we saw the early stages of evolution of what is known as the National Law School of India University, starting with Bengaluru, where the professionalization of legal education became an important priority, where the idea of essentially identifying young people out of high school, just as we saw in the evolution of medical education and engineering education, that became a focus. Since the establishment of the National Law School today, we have come a long way, and we have ended up having over 28 national law schools across the country, and I think that's a very interesting evolution. I'll come back to the current stage very quickly because I'm conscious of the paucity of time as well. And today we are in a situation where, and I would say that what began in 1987 essentially continued, and to some extent continues even now, but I would like to say that since the late 90s and even early 2000s, we saw a challenge to that paradigm and more stronger focus on idea of how India can interconnect with the world and to what extent globalization of legal education can impact Indian legal education has been a part of a larger discourse. The establishment of Jindal Global Law School and our own university and several other institutions since then is part of an effort to globalize Indian higher education and Indian legal education. When I look back at the last 75 years of the evolution of Indian legal education and looking forward towards 2047, I can say with the full sense of conviction and responsibility that we are facing a crisis in legal education. This crisis in legal education has had a significant impact on institutionalization of mediocrity across the legal profession, and I dare say infusing that even in the judicial fraternity. This aspect of mediocrity that has been deeply embedded in our legal education is reflective of a larger problem that we're facing today. With over 1,750 law schools in India, with a large number of, since 2009, we ended up establishing over 700 law schools. So the pace and the speed and the expansion of legal education and law schools has unfortunately resulted in high levels of mediocrity embedded in our institutions. I also see that the possibility for change happening in our law schools is becoming limited, with a greater focus even from the standpoint of internal institutions to professionalization of legal education, whereby law and its grand vision, including interpretation of law, evolution of law, scholarship in the field of law, publications in the field of law, all of which are so limited in the Indian context. While there are pockets of excellence that are spread across the country, including some of the national law schools and some of the traditional public universities and a few of the private universities too, it is only fair to say that we simply have got into a conundrum whereby we are not able to reimagine the future of legal education. I also want to quickly shift to the fact that, to a large extent, I will say that this responsibility of not taking legal education seriously is not only confined to academia, but also this responsibility needs to be shared with both the members of the bar and the bench. The members of the bar historically have looked at law schools from two lenses. One, to be able to occasionally give lectures and seminars on issues of great importance. And second, the evolution of the corporate bar, as well as the law firms and even litigating lawyers, to be able to recruit young law graduates or even law students as internships as well as lawyers. They have not looked at law schools as possibilities of creation of knowledge, contributing to research, addressing some of the fundamental issues surrounding the field of law. If I were to compare law schools around the world, especially in the United States or in the UK, where Oxford and Cambridge or Harvard, Yale, Stanford, Columbia, Berkeley and other major law schools have made immense contribution to the evolution of the field of law. They have recognized that the law is an instrument of social change and social engineering, and some of the fundamental ideas relating to law has emerged out of the work of academics and scholars in universities. In fact, in the United States, it has always attracted law professors have been people who ended up becoming judges of the court itself. My own teacher at Harvard Law School, Elena Kagan, was my constitutional teacher, later became a judge of the US Supreme Court and now currently serves as a judge of the US Supreme Court. And there are numerous examples of lawyers ended up becoming attorney general and other members of the legal profession, but also law professors becoming attorney general and other members of the legal profession, including judges. In fact, although there is a provision in the Indian Constitution for the appointment of a distinguished jurist as a judge of the Supreme Court of India, quite unfortunately, we have never exercised that provision. And that takes me to an equally important part, which is that we simply need to work harder with regard to improving the quality of adjudication and indeed improving the selection of judges as well. While one facet of the mediocrity in legal education is impacting the legal profession, another facet of it, I believe, is also impacting the ability of us to attract fine judges as a part of their ability to advance the cause of the rule of law. I want to end by saying that I strongly believe that as we look at 2047, we will not be able to develop a robust legal culture, a robust legal profession, and to be able to attract fine minds into the judiciary if we do not focus on legal education. A lot of attention needs to be paid by the distinguished members of the bar and the bench, and legal education cannot be relegated only to a few regulatory bodies as well as academics for it to be achieving its fullest potential. I also believe that we need to, one of the challenges of this evolution since the late 90s especially is that the diversification of the legal profession has led to significant opportunities that have emerged for young law graduates to enter the corporate transactional work. But a consequence of that also means that we have not been able to attract finest minds into the legal profession. There's something to be said about the fact that the best of our law graduates are increasingly, for a while now, entering into corporate transactional work in law firms, and nothing wrong in it. But I must say that we need to create an ecosystem and an environment in which first generation law graduates need to consider legal profession and even potentially becoming a member of the judicial fraternity. It is not enough for us as academics, lawyers and judges to exhort our students to come into the legal profession. We need to create an enabling ecosystem whereby they are able to make those choices. When I graduated from Delhi University in 1997, I remember very vividly, most of my classmates were second and third generation lawyers, but I wasn't, and I would talk to several of my friends, and it was quite remarkable. Very distinguished members of the legal profession, including lawyers, when my friends were trying to enter into these chambers, they would be told that when they asked about the compensation or salary, these lawyers, and I don't want to name anybody, would say, you should consider yourself quite honored that you are even having an opportunity to work with me. Forget the possibility of being compensated. And this trend continued for a very long time till recently, and I have heard several stories from many of my classmates and juniors and seniors, including that the senior members of the bar rarely used to pay to young juniors when they joined their chambers. I am glad that that trend has changed. A lot of young members of the bar who are already doing very well have had a tectonic shift and impact in the legal profession, and they are encouraging young lawyers to come into legal profession. So I want to end by saying that we need to pay greater attention to legal education if we are to strengthen the legal profession. And I do believe that strengthening a legal profession means recognizing the importance of rule of law, recognizing the need for protecting and promoting the rule of law, and to ensure access to justice, because lawyers have a very big role to speak truth to power, and in that process strengthen the democratic institutions, the edifice of which is our own country's journey. If we ignore this particular aspect of it, I'm afraid the future may be potentially bleak, and we would have lost a great opportunity. With those words, I want to thank you for this opportunity.
Thank you so much, Dr. Rajkumar. That was very enlightening. And I already have a question for you, but I'll come to that a little later. Mr. Bharuka, may I now request you to address?
Yeah. Thank you, Gaurav. Distinguished panelists, respected teachers, very dear Sindhian friends, ladies and gentlemen. Just to continue with what Professor Rajkumar said, I remember my own days when I just started with the practice on a very light note. I joined a distinguished senior, and he offered me to pay $2,000 per month, which was really peanuts even at that point of time. But what is interesting is he asked me whether you know typing. I said, yes, I do. So that's an additional advantage, $500 more for that. So yes, the entire approach really was quite different as opposed to over the time, the way things have changed. So I'm supposed to just I'll try to see how the certain right, the right to life, has evolved over the time since the independence. At the time when the Constituent Assembly was discussing the various issues about the fundamental rights, they were the members who had gone through the brutalities of the British colonial rule. They had actually suffered through the brutal police forces, and they knew exactly how it is important, as Chief Justice Singh rightly indicates, to recognize and to ensure that the certain fundamental rights are a part of the Constitution which cannot be altered under any circumstances. Those rights were always there. As a human being, we do have a right. It's an inherent right for me to have a living of my own and the way I want to live. But those were specifically noted and recognized in the Constitution. And second most important thing was really to have a judiciary who is able to understand the needs of the people as the society moves on, and to be able to then interpret the law and infuse more depth and meaning to the words used in the Constitution. So when it's just simplicity, Article 21 says the right to life, the word life itself has such deep meaning that in terms of how society develops over the decades, that meaning has to change, it has to alter. The purpose of law really is to be able to regulate the behavior of members of the society. But at the same time, the purpose also is to be able to appreciate and understand how the members of the society are moving forward, what is the need of the people, what is the need of the hour, and then to be able to mold the requirements of the members of the society into the legal framework. So over the decades, how this entire law in terms of right to life altered is what is reflected in the various judgments which comes from Supreme Court right from 50s. So the earlier decade is what we see in terms of what would say the basic rights, human rights, which started emanating. Basic right to have a shelter, right to be able to earn a livelihood, the basic rights by which a human being will be able to survive in the society. So those were the rights which we saw from the court developing from this entire meaning of right to life. As we move forward, considering again our past practice, the criminal jurisprudence developed, where we have a right of a fair trial, where we have a right of a speedy trial, where there was a need that unnecessary handcuffing should not be there. There should be a need that solitary confinement in the jail should not be there. The rights of the prisoners. So the entire criminal jurisprudence again arose from what we call as the right to life. We moved forward a few years ahead into the decades, and we saw the development of the environmental laws, the right to have proper environment, the right to have pollution-free air, the right to have pollution-free water, how it's important that the wildlife should be equally protected as we are, as humans should be protected in a society. So these were the rights which kept developing over the decades as different issues and questions came about before the courts. What is really important is that the courts were alive to the situation and the needs of the people. So there are really two ways how a law would develop. One is by way of legislature, by way of the lawmaking powers of the parliament or the legislature. But as we see, the parliament sometimes gets slow in terms of development because it has its own complete procedure in terms of how it would lay down the law, how there will be discussion in the parliament or in the legislature, and how then the committees, etc., would work through it, and finally a bill is made and then the act is passed. But in the interregnum, there could be sudden need, urgent need of the society that the law should urgently develop to a situation, and even if there is no such parliamentary framework, there is certain law which is developed in the process so that the rights which again are inherent to us as a human being are available to the person who is approaching these forums. After all, these different organs of the state, the judiciary, the executive, and the parliament, ultimately they are there, they exist for the need of the people. So this indication really what again Justice Singh has indicated about a certain provision of the law in terms of Article 141, that the law declared by the Supreme Court shall be the law of the land. That law really is the law which the courts develop when a particular person in a certain situation approach the court and indicate that this is where the problem lies on a factual basis. Court appreciates that, interprets the law, and is able to evolve those rights which apparently might not be a part of the system and apparently might not be strictly in terms of the letters of law. So it's the interpretative process by the courts is where we have these new rights being constantly evolved. So we have these traditional rights building up, but now let me just focus a bit more on how the recent rights have been developed in two larger parts. One is in terms of the norms of the society, how it's been changing over time, the thought process of the younger generation as they move forward. And the second part is this entire gamut of internet and how it is affecting our society and what kind of rights one is expecting one should have in terms of protection. Now the first part is where there are situations where because of the relationship and because of the behavioral tendencies of people and especially even the younger generation to move forward in a certain manner which might not really be in tandem with what has been happening in the past. And that's where the courts come forward and help when these issues come about. So let's take a very simple example of marriage. Now, marriage is something traditionally, really traditional, is what we used to always call ourselves as an arranged marriage. A girl or a boy, they're already now of a marriageable age, the family members would look into it. There's always a belief in the Indian system that this marriage is not only about individuals, it's about a marriage of the families. So in that situation, there were certain norms created, be it on the basis of religion, be it on the basis of caste, be it on the basis of geographical region, could be many more factors. In this situation, when over time, as things move forward, then what we call as the concept of love marriage came about, and when there's a boy or a girl and would want to marry each other, and then they find that the families are completely in debt against that kind of a marriage, then the couple tends to and takes a drastic step of moving away from the family, eloping and then marrying. So there have been instances coming from the courts where the parents of the girl would come to the court and they'll file a case, an FIR of kidnapping of the girl, and they would say the girl has been kidnapped and now we don't know where she is and therefore it needs to be found out. But the fact remains that the society is moving forward. The thinking of the generation would be that no, we are an independent adult and therefore post 18 years, once we become an adult, we have a right to marry whomsoever we want. That's my right to choice and therefore that's my right to life. So connecting that, the courts have come forward, appreciated these, and they have actually protected the couples on and off in terms of saying, yes, the right to marry someone is your choice, it's a part of your life. So that's how the interpretation, unfortunately, there have been cases we have seen of honor killings on the basis of these kind of situations. But that's where the courts have come forward in terms of stepping in and then protecting. So that's one of the rights which have evolved over time, the right of choice to get married. Connected to that is this entire concept of live-in relationships, which is again in a traditional Indian society something which would not really be accepted in terms of suppose the boy and the girl, they are working, they are not married, but they are in a living relationship, they are living together. That's something which is objected to, but again the courts have come forward and they have evolved this right again from the right to life, and they've given a legal sanctity, saying there's nothing wrong if two consenting adults are wanting to live together despite having a marital relationship. That is their choice, and therefore they can move forward in their life and they have the legal protection, even though there might not be a specific law saying there is a legal sanctity to a live-in relationship, but the courts have evolved it from the right to life. So live-in relationship is another in terms of marital issues which has come forward. The entire issue we had about the LGBTQ community, who had over the decades suffered at the hands of the society, and especially our criminal process of our Indian Penal Code, which criminalized that kind of I would say a sexual orientation, which was taken to be something sometimes even of a disease. So those issues had come over. The Delhi High Court had held that that is something which has a legal sanctity. Supreme Court initially reversed it, but finally the Supreme Court held that that again is a part of right of life. There is something which is a person, if he has a choice of living with whomsoever he wants, if he has a choice of marry, then they also have a choice of sexual orientation. So in terms of recent developing laws, in terms of recent developing rights, this was a major watershed in terms of how the courts are looking at an individual's right to take a decision, even in an area of a sexual orientation and how they would want to look into it. So that's another area. Another very important area, I think, in terms of recognition to a community was the transgender community, where we were psychologically, or maybe even I as we grew, when you look at the transgender, you wouldn't have that connectivity as a human being. So what we have to really understand that they are, after all, a human being, and when you connect them as a human being, in that situation, that's where we feel the transgender community is very much part of our society, in whatever manner the entire structuring is, but that's a different thing altogether. The courts have again evolved this entire concept of giving proper recognition to transgender communities and to be able to giving them the due rights as a human being. So now we see in all these forms, etc., where you have a gender column, you do have a male, female, and others. So that's something which is important. So this is another issue which has really been evolving over time and finally been giving proper recognition, I would say due recognition and overdue recognition to this community. So these are different areas where when the society moves forward, when there are changes happening, the courts do step in when they are faced with a situation, and they evolve the law as they move forward. So this is one part, really, in terms of, there are numerous instances of this kind. Suppose differently abled people, Now, differently able people are again some people who are not being given their dues. There was a case where in the SpiceJet, a person with a prosthesis limb, he entered, he was wanted to read the security check, he was asked to remove the limb, and then in a very, very discourteous manner, he was actually carried, physically carried without his consent. So the courts heavily came down saying that you have to give due respect to a differently able people. They do also have rights equal to any other person who would have a right. Constitution for that matter is applicable to everyone. Article 21 is applicable to everyone. And therefore, then they laid down the entire guidelines about how in civil aviation areas, how one should look into it. The directions were issued to the Director General of Civil Aviation about how airports should take care of such people. There should be sensitization. So that's, I think, another very important aspect which has been looked into in terms of sensitization of the members of the society, that how these different communities, though they might be in kind of their own different zones, but they are equally to be respected as a human being. So these are certain of the areas which have been evolved. Now, in terms of going onto the internet, let me just first start with the very important aspect of right of privacy. That has again evolved over time. Earlier, it wasn't really recognized in this manner, but there was one very interesting case where the police, under its powers, and again, that all that police force powers, they would actually go knocking on the doors of a certain person who had certain criminal antecedents, but they had the power to knock on the doors even in the night at domiciliary visits. So they would go around harassing this person. So he ultimately went to the courts, and the court recognized the right of privacy, saying that you cannot go around, whatever be your powers, but at this point of time, a man's house is his castle. That's the words which were used. That once that be so, you cannot really intrude into the privacy of a person. So from those days, we moved on to really to today's privacy situation, and the classic case is the Aadhaar case, where Aadhaar is the scheme which came about by the government. It says that you can have your Aadhaar card, but for the purposes I'm sure we all have done, you have to give your biometrics and you have to give all your other details. That issue then was challenged, that in terms of this entire biometric data being collected and the misuse, and that is why my privacy would be invaded. Eventually, court did recognize the right of privacy, the Constitution bench, in that judgment. It says that every individual has a right to privacy in different contexts, in its own terms, in its own ways. And though it upheld the entire scheme of Aadhaar, but that was for some different reasons. But the entire principle of Aadhaar, privacy was upheld. Now that connects now today with the privacy of the online data. Now today, the data what we are putting up, and so there are two ways. One is that I'm putting up data online voluntarily in terms of, suppose a social media use. So I'm putting up all that data over there, but I would want to know where my data is and who's using it and whether it should not be misused. Second, more important, is my personal data being collected by different websites constantly, be it my mobile number, be it my location. I think location is something which is now extremely critical. Every app you use today, they would want you that you should permit me at where the location is. Today you go to Google and you do the timeline. It can actually tell you almost in the last 10 years where all you have traveled all across. It's actually very scary. So the protection of the personal data is another burning issue which is now coming forth, in terms of how these companies will be collecting data, how they would be using it, and how they should not be used. And to that is connected is the right to be forgotten. The right to be forgotten online is another concept which is now being evolved slowly, that whenever I put up my data, and if I want to withdraw the data, suppose I open up a Facebook account, and I want to delete it permanently. So if I am deleting it, it should equally be deleted on the servers of the Facebook. It should not be that it should be retained over there in some manner and then used or misused in some manner. So the right to be forgotten in terms of my data and how the entire data should completely be removed is one area of the right to be forgotten, which is evolving at this point of time. Another part of right to be forgotten is in terms of something written about me on the internet. So there could be areas where something has been written which damages my reputation, my goodwill. So a very simple example is that suppose a criminal case is instituted against me, and eventually I am acquitted, so I am left off by the court. But in the meanwhile, the media has substantially covered me all over the place. Now in my future interactions, that data can be pulled out to my detriment, and therefore it's important that that data should also be removed in some manner, and there should be a regulatory regime. In India, we don't have that regime right now. There was a personal data protection bill prepared. There was multiple committees sitting. They're working on it right now, the personal data that controls that whoever has the data should be able to have the duty, the responsibility to remove it if I ask that. The data in terms of shifting it within India to outside India, that's another issue. So that's another larger area in terms of how the online information and data is being controlled. So these evolving rights, and I'll just close by saying that the courts and the parliament, the legislature, they have always been alive to these situations. Sometimes they do it on their own when they realize the situation which is there and new rights have to be developed, not only developed but recognized in a proper manner. But in case that be the situation, society immediately and urgently needs some kind of a development, they do go to courts, and the courts would step in and actually are able to do and build up these rights. Thank you so much for
Thank you so much, Devashish. I would now open the panel for questions. Any questions, please?
I have a question.
Yes, yes, please.
You are loud enough.
Don't need a mic.
Yes, absolutely.
Because the school taught me that if you have got to be a good person in dramatics, your voice should travel up to
That was the end of the assembly hall. Yes, yes.
That was Swami Sharan Srivastava. You see, finer points have been all discussed, and unfortunately the audience mainly consists of non-judicial people. Therefore, it's very difficult to comment on whatever has been said in its finer terms. But broadly, Constitution is the prime institution to serve society in an orderly manner. And that being the fundamental case, I see today so much of disruption and disruptive scenario in every field. And on top of it is the exponential evolution of technology. How the jurists are going to manage this situation is my question.
Professor Rajkumar, would you like to?
Yes, so several things. The most important part of this is that we should first of all recognize that technology, like everything else, is a tool that we need to effectively use. And it is not a value neutral tool in that sense that we should not only just celebrate all forms of technology, but we should be able to introspect it. In fact, in my own field of education, some of you may be aware that the ChatGPT, which has emerged recently, which is a very preliminary version of it, and I expect many more things going to come, we have to reimagine the entire teaching and learning system, including schools. We look at how we're going to test, how we're going to evaluate, how we're going to grade, how we're going to exam, how we're going to assess, all of which is going to be reimagined. So to answer your question, I do believe that there is a great potential for the use of technology. Artificial intelligence and robotics and machine learning are emerging technologies which will impact our life. Like everything else, we need intelligent and responsible people to evaluate the use of this technology. We should recognize the role of ethics, compliance, privacy, and all those dimensions which will inform and impact the world that we live through technology. There is nothing like, this is something that is going to change our lives, let's absorb it completely. There are very good areas where you can promote access, you can create opportunities for people to use technology, but the reality is, even in the legal profession, it is going to create a dichotomy. I'll give you a very simple example. In education, since March 2020 when COVID happened, many of us, of course, moved into technology. We had 2 years of online education. But the reality is, and I was shocked to know the data myself, that only 18% of Indian households have 3 things that are critical for any form of online education. First, a reasonably working electricity. Second, a reasonably working Wi-Fi. And third, a reasonably working equipment. Which means 80%, over 80% of Indian households did not have any education. UNESCO has estimated 1.4 billion young people were removed out of education around the world during COVID, and they are not going to come into it. So in a way, my response to that is, we need to, as intelligent, responsible people, we should neither deny the role of technology nor completely take everything on board. We need to interrogate it and make it available on areas where we think it is in the best interest. I don't believe it is going to replace what all of us are going to be doing in any field. It is going to have a very significant role, but it is also going to become responsible on our part how we are going to use it effectively.
With this, I would like to express my gratitude. We're very short on time. We're already running late. I've been getting feelers from the right-hand side that get off the stage. So anyone who has any questions may ask the panelists personally. And with that, I would like to express my sincere gratitude to all the panelists here, Justice Bhatia, Justice Singh, Professor Dr. Rajkumar, and my friend, Mr. Devashish Bharuka, for making this session possible. Thank you. Thank you so much.
Request some Scindian wives to please present our token of appreciation on behalf of Sobha to our panelists, Sonika, Dipti, Sudha, Noorjahan, and Roli, please.